Hello and welcome to the Disability Law Show. Thank you so much for tuning in. Got 30 minutes to fill your head full of knowledge if you've been dealing or have dealt with, or a friend or colleague, family member with a disability insurer, and you're getting some trouble, you're getting some static. There's solutions. Listening to this show is one, and always reaching out to Tamar Agopian is another. Tamar Agopian for Samfiru, Tumarkin LLP, stlawyers.ca. I'm John Scholes, just the host. She does all the heavy lifting. All the brain power's on that side of the table, okay? So just going forward, know that. Anytime you want to reach out to Tamar, though, a phone call will cost you nothing. 1-855-821-5900 to do that. Email us help@disabilityrights.ca. We'll give you some other contact information throughout the show that you can use whenever you want. And the main topic this week is how your doctor can help your LTD application. That's on the way here in just a bit. But we got that, some phone calls from our radio show tomorrow, but we always start off with the week that was. My friend, what do you got going on?
This week I want to feature a situation that someone who reached out to us is encountering. Let's call her Mary for our purposes. And so Mary calls us because she's in a situation where she was denied her disability benefits, and she was denied a couple of times, no surprise there. But what was interesting about her situation was the underpinnings of that denial. So we know, John, that the basis to be approved for disability benefits is this idea of total disability, right? It's a concept conceived of by these insurance companies. What does total disability mean? You know, most people assume it means you're laid up in bed and you can't do anything, but that's not Mary's situation. But certainly she had the support of her doctors that she shouldn't be working. She's in her 40s. She was doing an admin assistant type position. She had been doing that for a number of years before she started to become very sick, fatigue, nausea, wasn't sure what was going on. And she was diagnosed with type 2 diabetes. Now, this is significant because fast forward 6 months, and she finds out that she's actually been misdiagnosed, and she's actually type 1 diabetic. Now, look, I'm not an expert in diabetes, and perhaps an insurer will say that diabetes alone is not sufficiently disabling, but certainly the misdiagnosis was a problem for her. Type 1 is actually much more severe. It has a greater rate of fatality and mortality, unfortunately, and this naturally caused a ton of anxiety for her, and she developed mental health conditions. So you had physical elements in her disability, and then you had the overlay, the on top of, with the mental health components. And yet, the insurance company kept denying her disability benefits. And so I was speaking to her, and I'm scratching my head, and I thought, well, what's going on here? And she said to me, John, the insurance company assumed that her job, the essential duties of her occupation, were sedentary in nature. What does that mean? It was a sitting down job, answering phones, typing, and this kind of thing. And Mary told me that's not actually her job. Even though her job title was administrative assistant, she was actually doing far more than that. She was driving on occasion to deliver things and pick up things for the office that she was working at. She was having to lift boxes within the office. So there were elements to what she would describe as the essential duties of her occupation that the insurance company hadn't taken into consideration. And we know that that is the test to qualify. So not only were they turning blinders to the severity of her mental health condition and the fatigue and all of the challenges in controlling her diabetes condition, but they were also not looking at the right occupation. So I said to her, Mary, you've got a good basis for a disability claim. You should absolutely be asserting your legal rights in a situation like this. And it actually is frustrating that you've gone through these appeals because you're not going to convince the adjuster that they've got it wrong because they don't see that the occupation hasn't been properly defined, properly described to them from your employer. And I know there can be a disconnect, and I know that's challenging for people when they're trying to deal with their health at the same time. But if they're not going to accept what you're saying to them that's disabling, what your job duties are, like she couldn't drive for a period of time and so on, then this is the breeding ground for asserting those legal rights. And I don't want to be casual about it. And I wasn't casual with her about it either. I said, look, I know it's a difficult decision to make to involve a lawyer with your claim, but it avoids the temptation that these adjusters have to be casual in their review. And so if they're going to treat the claim this way, you want them to take it seriously. And I can assure you that when we're involved, myself, any member of our team, the insurance company is going to appoint one of their in-house lawyers And those are the individuals we're going to be working with, not the adjuster who has the definition wrong and has your occupation wrong and is ignoring medical information. We're going to have all of that set out in the legal claim, and we're going to leverage that to get Mary the compensation that she should have gotten months ago, John.
Do you think part of the reason why they're doing this and they're digging the heels in is because maybe they're not recognizing the mental component of the diabetic diagnosis? I mean, you and I probably each know 6 people that are diabetic if we thought about it, right?
Right.
Maybe type 2, which is much more treatable, but this isn't a health show, it's a lawyer show, it's a law show. But do you think maybe the insurance company is saying, yeah, the physical piece, we have people that work in the office that are diabetic, have a desk job, you're fine, we're not going to approve your claim. But they're forgetting about that part because it's always that subjective evidence. It doesn't show up on an MRI.
Absolutely.
Or an X-ray. So that might be part of the problem, right?
100%. There's no doubt in my mind that because she's got some complexity to her disability claim, when you've got a physical component and a mental health component, it's very easy for the adjuster to ignore one or the other, or frankly, not understand and appreciate that one can negatively impact the other. So when you're physically unwell, it's not surprising that you may develop mental health conditions. And adjusters don't have any medical training, and all they're looking at is the paperwork that's being submitted, and then sort of looking at this somewhat routinely, as I described, and issuing that denial letter. And so I think with mental health in particular, they've come a little bit of a ways, John, but this understanding around symptoms being disabling in and of themselves that cannot be scanned or reviewed or tested, that is still the missing link of getting people like Mary over that hurdle of getting her disability benefits approved.
Good website for you called pocket-disabilitylawyer.ca, pocket-disabilitylawyer.ca. It's a beauty. Tamar, tell me about it. I know you use it, or have your clients use it too, right?
Both. I've used it, my clients have used it, my team has used it. Why? Because we are trying to push out as much free information, John, as we can, and make it as simple for people to use as possible. There are drop-down menus on this website. You can plunk in just a little bit of information about your disability claim and find out what your rights are. Completely anonymous. If you don't want to speak to any one of us, that's absolutely fine, but at least to be empowered with this information. Great website.
Phone calls. We take them on our live radio show. Have you ever caught us on the radio? Tamar does a fantastic job. Our good pal James Fireman, Savannah Tumarkin, the boss, does a bunch too. And you can tune into those. Simply go to disabilityrights.ca. There's a media slide there. You can find out a station near you that carries our show. Not only can you tune in for the hour, you have the opportunity to call in and join us on air and ask your questions as well at some point. The first phone call from our radio show is coming up right now. Let's have a listen.
I've gone on disability. Disability was related to employer issues. So I've been off without pay, and I submitted clinical notes to my insurance company, doctors, therapists, now on new medicine, and actually have not once been paid and been denied twice. So I'm on my 3rd appeal with the insurance company.
Oh, I knew that A word was coming up. Just didn't know it was going to be 3 times.
Aye. It's so frustrating, John, because this is really where you see what I call to be the interplay, the mix between a poor employment situation that then leads to health issues. And the trouble becomes the disability insurers don't want to get involved in a bad work situation. So they're very live to this right out of the gates, unfortunately for this caller, because they will look at this and say, well, if you've got some problems at work, this is a work issue. Yeah. This isn't a disability issue. We don't want to see your disability claim in a situation like this. But it's far more nuanced than that. And this is why our firm is so well suited for this, because we do employment work, we do disability work, and you can see the mix. Now, just because your disability comes out of a poor work situation doesn't mean that automatically disentitles you to disability benefits. We've actually got a whole show on this, so if you want to look at past shows, take a look. But truly, if your doctors are supporting that this isn't something that is in that situation, situational anxiety, situational mental health conditions, if it's something that even though you're outside of that work setting that's causing this and still experiencing symptoms, then by all means, you absolutely have a valid disability claim. If the question is that you just can't work there, or is it that you can't work at all? And that's really the defining feature of whether this is a disability issue or an employment one. But either way, John, I don't like the idea of anyone appealing in a situation like this, let alone 3 times, because you're not going to convince the adjuster. Let me give some context to this. The adjuster will look at the paperwork, they'll look at the application. One of the first steps that they take is they actually write to your employer and say, hey, were there any work issues with this individual? What was their performance like? Did they have any days off, sick days? Was the employer aware that there was any health issues? And they will ask these 3-4 questions, typically in writing. I mean, I never know if they have a phone call with the employer, but let's just assume it's only done in writing. Well, if the employer then advises, yeah, you know what, there was a personality issue or there was an issue with, that was reported to HR, well, then the insurer has that information. And you as a claimant don't even know that they have that information and that's maybe what's informing the decision to deny the claim again and again and again. But when we get involved, we'll actually ask for a full copy of the claims file. And I get to look at it and I get to see what questions they've asked. I get to see how much information the insurer had, and if in fact it was a dressed up denial. So it's a denial that it's all workplace related, but we're gonna give her a different excuse, which is we don't think you're sick enough to make a valid disability claim. And so this is why it's so important to retain a counsel, retain a lawyer, and assert your legal rights.
Let's take a short break. Lots more to go. How your doctor can help your LTD application. That's coming up on the other side. And in the meantime, call Tamar and her team with your issues. No problem. 1-855-821-5900. This is the Disability Law Show, and there's more on the way. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back to the Disability Law Show. Your host, John Scholes, lawyer Tamar Agopian from Samfiru, Tumarkin, LLP. Reach out to Tamar. Have that conversation if you've got questions. Don't be sitting there in the dark scratching your head. It's 1-855-821-5900. Help at disabilityrights.ca through email. We'll try to get to some of those a little later on the show, but I mentioned our main topic, that is how your doctor can help your LTD application, because your doctor, Tamar, your medical team is just as big a part as having a good lawyer on your side. You got to have the medical team, right? Got to have them.
100%.
Gotta have them. Otherwise, you're getting nowhere. Number one is this: provide detailed reports that offer specific information relating to a claimant's symptoms and their inability to work. What do you think?
So I'm going to take a step back before we start to tackle this, because you hit the nail on the head, John, that the importance of your own medical team is critical in any disability claim. That is the starting point. You want to make sure that your doctor has symptoms well documented, diagnosis if you've got it, treatment measures. All of that have to be put in place as you're trying to make that application and then continuing those LTD benefits with your disability insurer. Now look, we are not doctors, right, John, but we understand what the insurance company is looking for. Many of us have spent some time working on the dark side for these insurers. That's right. And so we know that they are doggedly pursuing the medical support that they need to justify cutting that check every month for the LTD benefit. And so I cannot emphasize this enough. Yes, we are not doctors, but the doctor that you do have is the starting point, the focus of trying to support that disability claim. And then I'm going to use another little adage, which is you want to spoon feed this information to the insurance company. Do not assume that the adjuster has any knowledge about your disability. Do not assume that they've had any training on looking at the information that your doctor has provided. So the more information that there is, the greater the detail that the information that your doctor provides, the better it is if or when the insurance company denies, okay? Now look, my hope is that if you provide everything, it should be accepted and reviewed, and you should be getting your disability benefit. But we have whole shows on why this doesn't necessarily work, which is why we're dealing with this topic, how important it is when you're making that application to explain to your doctor, look, hey doc, I know the paperwork takes time and energy, and I understand all that. So can you maybe just complete the form and then include your clinical notes? Can you put that testing result in? Just put it all in there. Don't hold back any information from the disability insurer, because you want all of that available when they're looking at your application.
And kind of an aside to that first point is that you guys as an insurance or as lawyers never tell doctors what to say. You're not qualified to do that, but you can help them if they're not familiar with filling out these forms and what's needed to move the case along, right?
100%. And this is where I'm going to lean on yet another tool that we've created, which is the LTDFAQ.ca. Yep. If you go to that website, we also have memos. We've got a guide, actually, that you can take to your treatment provider to give the insight to the doctor, the therapist, whoever it is that's treating you, to allow them to understand what type of information the insurance company is looking for. Because this isn't easy for the medical practitioners either. This isn't something that they normally deal with day in and day out. They don't know what to do with these forms. And frankly, the forms themselves only give you little boxes to check things off or put a few words in. And that inclination is too easy for doctors to do without providing that extra substance that may be needed. The narrative report, the explanation that I've been treating this person for 12 years and I've seen the decline in their health, for example, or this is why that I've explained to them that they need to stop working as a result of these health issues. So look, not an easy situation to navigate, but there are some tools out there, and LTDFAQ.ca has some really good memos on that.
Again, as Tamar just mentioned, wisely done, LTDFAQ.ca. But doctor, can I help your LTD application? How? Number 2, refer a claimant to necessary specialists. We're talking psychiatrists, physiotherapists, that type of thing, yeah?
Right, and so this is where I'm going to pause and talk about these long wait times that we're dealing with across the country, especially psychiatry in particular, but we see it even with therapy clinics, specialized, the long COVID clinics, the Women's College Hospital. There's a few places where the wait times are sometimes years. But if you have the referral, if the doctor has at least started that process for you, that in and of itself will demonstrate to the insurer that there are symptoms there, there's treatment that is being pursued, and that you require more specialized assistance or assessment beyond what your family doctor can provide. It makes perfect sense. But this ties into that requirement, John, that most policies have that say you have to be under quote-unquote appropriate treatment in order to get your LTD benefit. So it's not just you have to meet our test for disability. There's all of these other requirements that they've built into their policy, and this is one of them. But insurers are impatient. They don't want to wait for that wait time. So I have seen insurers deny claims when people are waiting for knee surgery, when they're waiting for the specialist appointment. But the referral has been huge for us in our legal realm to leverage that against the insurer to say, well, hang on, you cut this off prematurely, or you should have really approved and waited out the process to allow this person to get the treatment that they need. This is not the person's fault. It's not even their own doctor's.
They're not malingering. They just can't get to the appropriate treatment, right?
That's exactly right. And so I think this is going to become more of a hot button topic as we go ahead, because the wait times are not getting any better, and I think insurers are getting more and more impatient. Yeah. So again, very important to have those referrals in place, very important to have that comprehensive medical.
Discussing how doctors can help your LTD application. Point number 3 for today is ensure claimants are seeking and following recommended treatment. That's on you.
It is on you. It is on the claimant to ensure that they're following medical advice. This is reminiscent of insurers really like to comment on whether or not someone's being compliant or non-compliant with the medical advice they're being given. So for example, taking pain medication, that could be somewhat controversial, or getting treatment from a psychiatrist as opposed to a counselor or a psychotherapist. Those are the 1 or 2 areas that I see quite commonly where a claimant is saying, look, I don't want to take very strong pain medication in order to be hopped up on meds just to get back to work, insurance company. But then you want to have that careful dialogue with your own medical team. This all comes back to you having that open conversation with your own doctors, your own medical team, on what's best for you. And if something is being recommended, even if it's just as simple as taking a certain vitamin or perhaps doing regular walks, perhaps trying to lose a little bit of weight, please do try and follow those recommendations, because I have seen those kinds of small issues be everything for insurance companies when they're denying claims or trying to defend these legal actions that we're bringing forward. So really, really important, helpful advice on how to capture this and try and have the best package available so that you can try and get those LTD benefits approved.
The moral I think we talk about every week with, as far as the claimant side is concerned, just follow through with your treatment and be honest to the insurance provider, then you have nothing to hide, and there's no reason why you guys can't battle and be successful. I mean, we joked about that picture that came out a short time ago, that woman in the States who was cut off her denial because she was in a Christmas tree chucking contest. There's a picture of her lofting it. Okay, you've kind of breached your policy, but for most people, they don't do that, and they are legitimately in need of these benefits.
You know what I don't like about that news report, John, is the fact that it breeds into that cynicism that most insurers have about legitimate disability claims, right? And so insurers will come at it just assuming that, well, if you're going for a walk every day and going to the gym 3 times a week, it must mean that you can work. They assume function when function isn't there. So I 100% agree with that recommendation. You want to be open and honest with your insurer. You don't have anything to hide. Most people legitimately want to work and be better and be healthy. But then lean on your medical team on what that right balance is for you with health, recovery, exercise, all of those things, and have all of that available to the insurance company for review.
We're going to lean on one of your emails after a short break, which we're going to get to now. You can send one along anytime. It may appear on a future show. How do you do that? help@disabilityrights.ca, or go right for the phone call. Talk to Tamar and her team, 1-855-821-5900. More of the Disability Law Show is on the way. Stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Well, thank you so much for sticking with us through that little break. We got lots more to go here. As I mentioned in email as we got into the break, let's get to that right now. help@disabilityrights.ca. For today's show, it's Victoria says, I've been on LTD for 4 years now due to inflammatory arthritis. I hope to try a gradual return to work, but was not given approval by my treating doctors. I've contacted my union, but they have been less than helpful or supportive. Is it possible for me to consult a lawyer?
Always possible to consult. Yeah. You're right, John. It's always possible, Victoria, to consult a lawyer. Anyone should at any stage of their disability claim. But I think with unionized people in particular, I want to pick up on that just for a moment, because I think there's a bit of a misunderstanding that just because you're unionized, that the only recourse that you have with your disability claim is your union. And by all means, you should consult your union. They are there to support you. You know, if you're a member of a union, you should absolutely speak to them. But I don't want just all unionized people to assume that this closes the door on hiring a lawyer and starting that legal process, or even consulting with a lawyer about what your rights are. Because although there's some case law that says that some unionized people cannot hire a lawyer to fight their disability claims, that is a very minor group of people. And our starting point is always to look at the collective bargaining agreement, and we get past that hurdle very quickly. So I don't want to be too deferential to the union, because frankly, they're not in the same position as we are, John, to provide this kind of comprehensive advice to people on how to navigate this. Because I see the right key things, right? She's been on claim for 4 years. You know, so she's gone past the change of definition, most likely. She's got inflammatory arthritis. There's not a condition that gets better. It gets worse over time. And now she's hoping to try a gradual return, but she hasn't gotten the approval from her doctors to do that. And what I don't want to see happen is her being led astray by the union, that the only option is either to appeal if the insurance company denies, or to just force herself back to work because she feels that that's what she needs to do at this stage. I really think in situations like this, it goes back to what we were talking about earlier in the show. The doctor is primary. You want to follow your own treating doctor's advice in a situation like this. You never want to set yourself up for failure when it comes to return to work. Because I can assure you, if you're on claim, especially as long as Victoria has been, the insurance company is going to be quite happy to cut you off or say, oh, you've returned back to work, we're not going to continue paying your LTD benefit. And so if you really don't have that support and it's not going to be a successful return to work, the last thing you want to do is put yourself back in a work situation that may exacerbate, may worsen your health conditions, and also potentially compromise the continued entitlement to your LTD benefit. So again, great that she contacted her union, but hopefully her very next call is to us.
Victoria did not mention in this email, Tamar, but I'm wondering, obviously she hasn't really consulted about the return to work with her treating doctors because they have not given approval. She said that. So where's this idea come up in her head? Is the insurance company saying, hey, you can go back, come on.
Of course they are. Of course they are, John. I mean, that feeds into every model of every claims adjudication. The number one goal is to always push people back to work, make it feel like that's the only option that they have, and that maybe they don't even need to consult their doctors because the insurance company is right. Again, that's a myth. It is not in fact true. You want to actually consult your doctors so that you have that buy-in one way or another as to whether the right thing for your health is actually to return back.
Let's get to another question. This time we're going to bounce over to mydisabilityquestions.com. Available for you anytime, free and anonymous. Chrissy, her turn, says, I applied for long-term disability due to a heart condition and my application was approved. I'm now being told by the insurance company that I must apply for CPP disability benefits. Do I have to do this? If denied, will this affect my LTD benefits? Love this question.
I love this question because we see different permutations of this a few times over. And the short answer is that your policy may require you, Chrissy, to apply. Some policies say you must. Other policies say if you're eligible, you can go ahead and apply. But at the end of the day, you want to do what's best and what is going to be supported by your own doctors, regardless of what's happening with your long-term disability benefits. Yes, the two work together, and I'll get to that in a moment. But just as a starting point, just because the insurance company says you must do something doesn't necessarily mean that you should. But from where I'm sitting, I think the good outweighs the bad. The pros are better than for CPP, 100%. Here's why. There is some interaction between the two. If you are getting CPP disability benefits and also long-term, the long-term disability insurer gets to take a credit or a deduction against whatever else you're getting from the government for this disability benefit. And so essentially you're going to get less money from the disability insurer. However, if you are approved for this benefit, you're also being approved for the idea or the concept that you are disabled, you've got a severe and prolonged disability. That is really the test to apply for CPP and be approved for CPP disability. And so if you're in a situation that you've been off for a fairly long period of time, there's really no prospect, at least at present, for you to return back to work, then it's not surprising that insurers will encourage you to apply for CPP. And the application in and of itself is an endorsement from your own medical team that you're not returning back to work. It signals the right thing that I think insurers need to hear, John, some comfort around the fact that they're not just grabbing LTD dollars and then turning around and returning back to work. Again, that's cynicism where insurers come from when they think everyone's just trying to, lace them for compensation, which is not true whatsoever. And so when you go through the process of making a CPP application, again, lots of paperwork, and it will include a medical form that your doctor has to complete to make that application, and a test that you're not capable of working right now or not for the foreseeable future. And sometimes that in and of itself is helpful leverage against the insurer. If they do eventually cut you off, which they inevitably will, then in a profile like that, more than happy to take on a claim like that on behalf of Chrissy or anybody else who might be in this situation.
Because it's arguably a tougher test for CPP, and once you're approved, they maybe letting the cat out of the bag. They generally don't come knocking that often to say, you getting off claim yet? You getting off claim yet? Once you're with them, right? So it's financially could be a good thing.
Absolutely, because even if you are cut off, if you've got your CPP disability in place, that will continue whether the insurer cuts you off or continues your benefit.
Exactly what I tried to say. You just say it so much better. And we're done for another week. Thank you so much for your contributions. Reach out now to Tamar anytime. Feel free. Phone call will cost you nothing. 1-855-821-5900. That email address we always use, help@disabilityrights.ca. And for anything else, simply go to disabilityrights.ca. Catch our radio show while you're at it. And we'll catch you next time right here on the Disability Law Show. Thank you so much for watching.